Welcome to a practicePRO CPD, brought to you by LawPro.
Welcome, everybody. I'm very excited for everyone to be here. This is the Managing Your Practice in the Time of COVID-19. This event is presented by NCA Network. For those of you who don't know us, we're a networking group for those who went to law school outside of Canada. This event is also brought to you by Toronto Lawyers Association. They provide networking events and legal research to the community, and they run the courthouse in the library. Today, we're having Judah Strovchinsky. He's the Director of practicePRO at LawPro. Judah manages and promotes practicePRO, LawPro's innovative claims and risk management initiative, including identifying emerging claims and risk, resource creation, and outreach to the profession. Prior to joining LawPro, he served as a policy counsel at the Law Society of Ontario, where he provided strategic counsel with respect to key issues facing the legal profession, including access to justice, professional regulation, governance, and legislative issues. Prior to that, Judah practiced litigation and served as a fellow at Physicians for Human Rights in Cambridge, Massachusetts, as president of Canadian Lawyers for International Human Rights from 2013 to 2018, and as a director of the Canada Millennium Scholarship Foundation. Judah has a Bachelor of Arts from McGill University in Humanistic Studies and International Development Studies, and a JD from University of Toronto, which is pretty impressive. A couple housekeeping issues I'd like to address before we hear Judah speak. This event is eligible for 1 hour of CPD professionalism. Ask your questions in the Q&A box, and they will be addressed by Judah. As well, attending this event means you get a $50 credit management, and I'm sure Judah will enlighten us on how we can apply for that. So without further ado, Judah Strovchinsky.
Well, thank you so much for that warm introduction, Kim, and thank you for organizing this event to both the NCA Network and to the Toronto Lawyers Association. It's wonderful to see communities coming together. It's always a pleasure to address members of the bar and to talk about the issues that people are facing and how to manage their risks. So thank you for having me. What I'm going to do is I'm going to share some slides that will be sort of our roadmap for today. And we'll take some questions along the way, but I may be pressing pause from time to time on the slides to look at the questions. So if I don't get to you immediately, don't worry, we will have answers. So here's a bit of a roadmap for today. I would like to spend a few minutes just talking about LawPro, who we are, some of you who are relatively new to the profession or who may be just about to get called to the bar. It's important to get a bit of a background and understanding of who LawPro is and what we do for you. I'll then turn to risk management. As Kim noted, I direct our program called practicePRO. It's our practice management and risk prevention program. And one of our pillars is to educate the profession, educate lawyers about the risks in private practice and tips to reduce them. And for today, we'll talk about two different areas. First, we'll talk about the general risks in private practice, and then we'll talk about some COVID-19 specific risks that we've observed. From that, we'll move to some tech tips. Everyone has moved to practice at home in some way, shape, or form. That has created new challenges. It also means that there are all sorts of tools that you may want to experiment with and see what works for you. So we've got some tips around that. And then some tips just around managing your career trajectory. And we'll finish off with a discussion of a few resources. So let's jump in with LawPro. We are your insurer. We're your safety net, your umbrella, protecting you from lawsuits that may be commenced as part of being a lawyer is the risk that you'll get sued. And in the majority of cases, when people do sue lawyers, it's without merit, but we're there to protect you and also ensure that the public knows that the lawyers who do have independent regulation do have a form of public protection through insurance. LawPro is independent from the Law Society. We're a fully regulated insurer. We provide errors and omission insurance to the over 27,000 Ontario lawyers in private practice. We also offer excess insurance, which is available for firms, and title insurance for residential real estate transactions. We are the mandatory insurance for all lawyers in Ontario, and our liability insurance covers errors and omissions and general negligence in the performance of legal services or the failure to perform your professional services. I'm not going to go through all the terms of the policy, but it is available for download, and you can see the 2020 policy language at lawpro.ca. We're a pretty busy shop. There are about 27,000 lawyers in private practice. We get almost 3,000 claims a year reported to us. Now, it's important to know that a claim is not necessarily a lawsuit. It's any time that a lawyer realizes that there may be a complaint against them coming forward from a client, that they can report it to us. And so that could be that you may have realized you may be behind on a deadline. You may have missed a limitation period. Your client might not be aware. You would come and report to us as soon as possible. That doesn't mean that the client has sued you first. As soon as you realize there may be an error or omission, you report that to us, and so we can help navigate the process. We have over 4,000 claims open at the moment, and it costs about just over $80 million a year in claims. We have hundreds of millions of dollars under management to address claims that are ongoing, and those are subject to rigorous management guidelines. And as a matter of principle, we try to repair mistakes where we can to avoid downstream further problems. We settle where there are meritorious claims, but we also vigorously defend where, on principle, we believe that the lawyer has done nothing wrong and met the standard of care. So the standard base premium is $2,950. It's usually paid by a law firm. If you're a solo lawyer, you're paying for it yourself. It applies to the individual lawyer. And it's on a $1 million per claim basis, up to a total of $2 million per year. It's a claims made policy, and it provides for both the indemnity and the defense are included in those costs. Now, there are other options, just like if you had an auto insurance policy, depending on how many kilometers you drive or how many years you've been on the road accident-free, or various other factors, you may be able to work with your insurer for a different rate. In Ontario, for LawPro, we have discounts available for new lawyers in practice, and we have discounts available for practice-specific areas where there's a lower risk and an access to justice need, such as in criminal law and immigration law. We also have reductions available for part-time options, and the one caveat is you can't stack all of these. I think otherwise we might be paying you. So the maximum discount is 50%. And just like with your auto insurance policy, if you've got a deductible that's standard, you can work with us to change that deductible, and it may impact on the cost. Now, your policy covers errors and omissions, but it excludes a lot of things that are pretty taken for granted, but let's run through some of them. We don't cover punitive or aggravated damages, fines, legal fees. So if you're in a dispute about the cost of your services, that's not an error or omission type of issue. That's a business issue, a client relationship issue. We don't handle investment advice that lawyers may be giving. That's not professional legal services as we define it. And we don't cover criminal or fraudulent types of matters or lawyer dishonesty. So you can go to lawpro.ca for the other types of coverages that we offer. I'm not going to go through them in detail today, but just a point that if you are practicing with partners, there's coverage that is available. There's excess insurance if the $1 million per claim isn't covering your risk. You can reach out to us. There are also other options on the private market for that. And you can check out our website for more information. One other point I'd mention, which I think is particularly important for foreign trained lawyers who may have been called in other jurisdictions, is we do have national mobility in place, and different Canadian jurisdictions will respond depending on the situation. But we do not provide insurance for legal services provided for other jurisdictions. So if you're providing an opinion regarding US law or other foreign law, it's not covered. if you're working with clients on cross-border issues, it may be worth noting to them that malpractice coverage is not mandatory in most American jurisdictions. So if they are worried about that, they may want to ask before hiring a lawyer in a foreign jurisdiction. We also have products in place to help when you leave or wind down private practice. We have a runoff that's automatic of $250,000, and you can buy up to $1 million of coverage. And particularly relevant for COVID-19 is if you're contemplating a temporary leave of absence, you can call our customer service line, and there are temporary leave permissions as well. As an insured, you have certain obligations, and we're an insurance company with fiduciary duties and and obligations as well. So one thing we ask is, as soon as you realize there may be an error or omission, you can report that. It's right at lawpro.ca. There's a short questionnaire. You'll hear back from us very quickly. Never admit liability or settle at your own cost. And to report the claim, just follow the online instructions. At that point, we have a duty to defend and a duty to indemnify. You can expect that we're going to be prompt, we're going to be responsive. We have knowledgeable lawyer claims professionals who have practiced, who've been in your shoes, who know the lay of the land, and who are able to work with experienced outside counsel to defend where necessary. And as mentioned earlier, we do repair where we can, settle where we must, and vigorously defend where appropriate. So that's LawPro in a nutshell. I'm just going to stop the share for a second and check on the one question that we had, which is, well, whether the recording of the webinar will be sent to us. The answer is we're not sure yet. We're recording, and we will review it and then determine whether it will be made available online. So stay tuned on that. So we're going to spend a few minutes now looking at risks. LawPro is an insurance company, and one of the benefits of having an insurer that insures all lawyers in the province is year over year, area by area, we have data that we can use to look at what are the common claims. And you can learn more all about them, not just here, but at practicePRO.ca. So here's a misconception, is that only bad lawyers have claims. Truth is, for lawyers within the last 10 years, about just over 40% have had a claim. And most of these claims are not with merit, but it is a cost of doing business that it is quite likely that you may face a claim at some point in your career. So it's important to keep that in mind. This is not necessarily a rebuke against you. And even if you did make a mistake, mistakes happen, we share risk. That's why we have insurance. Before making things worse, just get in touch with us and we will try to navigate the train with you. So just a few stats about claims. You saw there was a new lawyer discount, and in fact, most of the claims occur when lawyers are 6 to 25 years in practice. Junior lawyers tend to be in firms where they are supervised or on their own, but managing their risk and being very cautious in the types of files they will take on. It's at the 6 to 25 year point where people are either increasing complexity of their matters or they're taking on carriage of files as the major lawyer responsible for the matter, at which point, when there are errors, they're entered in their name. But we don't see any sensitivity by geography, whether you're Bay Street or Main Street. Firm size, again, we don't see significant differences. What we do see is that the claims are reported on average 2 to 3 years after service has been provided. Again, that's an average. I've also seen people come and call us the day that they realize they've made a mistake. I've also seen some of those claims resolved the same day, where it's a small issue, but it is an issue that is worth reporting, and where with the help of our lawyers, they're able to navigate how to discuss the issue with their client and manage their ethical obligations as well. So this is a pie chart worth remembering. If there's one takeaway from today in terms of how you manage your risk, this would be it. We all go to law school, doesn't matter where in the world you take it. We've looked at this in other jurisdictions that keep this sort of data, and these are pretty consistent numbers across the board. They're also fairly similar to what we see in other professions. Turns out it's not the black letter law that is going to sink a lawyer in most cases. The mistakes that are reported usually are around the big four: are communication errors, time management issues, failing to adequately investigate a matter, or the error of law, which is trailing at a distant fourth. But the vast majority of issues arise in the softer client management side and matter management, practice management errors that lead to mistakes being made. It's the same when you break it down by how much we have to pay out for where we have made a payment. Typically, by far, the majority of claims are related to communication, time management, and inadequate investigation. Error of law trending up at 18%, only 14% by count, slightly higher by description of loss by cost. But the point is that the big four, the black letter legal, no substantive legal issues, are not the single biggest issue. So let's untangle what we mean by those areas. When we talk about communication errors, we're talking about failing to follow a client's instructions or not getting proper consent or an informed client instruction, doing work without authorization for doing it, or running to the next step of a matter without working through the implications with your client. This is generally a poor communication type of error where the client doesn't fully appreciate what's happening on the file or didn't understand that the file was going to proceed in the way it did. What these end up being are he said, she said battles, where a client comes and says after the fact, I didn't expect this. This was done without my instruction or without my knowledge or without my understanding of the implications of this decision because it wasn't adequately explained to me. And if we don't see contemporaneous notes from lawyers documenting their discussions with clients, it's very hard for us to defend these sorts of allegations. Although we're officers of the courts, we also see many clients a day at times, and it can be very difficult for us to say 6 years down the line at trial what we remember from a half-hour intake meeting, for example, with the client. That client might have only met one lawyer in their life. They might remember absolutely everything, which boardroom they were seated in, what type of coffee you ended up serving them, what color shirt you were wearing. They'll have that sort of detail recall, and on a credibility battle, there's exposure. So when we talk about time and calendaring, and this is the #1 area for plaintiff lawyers, more so than communication, but is a big piece of the puzzle across all areas of practice. It's usually about dropping the ball on limitation periods, seeing a matter administratively dismissed after 5 years, failing to calendar properly for court appearances and then not attending, or failing to simply properly follow up on your files due to procrastination or simply not lining up your ducks to get jobs done in the way and in the time that they are required. And so we see that from time to time. And that is just procrastination and calendaring timing errors generally. Inadequate discovery of investigation of facts is linked to the first two, is linked to questions of timing and linked to questions of client communication. This really goes to not knowing enough about your client's case, not knowing enough about your client's needs. That can be simply not understanding the client objective when they want to redo their will. It could be not getting all the documents you need to successfully run through a personal injury matter. It could be failing to conduct necessary title searches or property searches, not getting the appropriate expert, failing to identify all the parties. There are all sorts of ways where lawyers may not have dug deep enough, be it on a corporate commercial or on a retail law or on a litigation type matter. So failure to know or apply the law is, as I mentioned, in most areas, a number 4 in area of claims, or not the lead. There are certain areas where this becomes more prominent, such as in family law, where there are overlapping areas of the law. So you can have your general child support requirements, divorce, tax implications, real property law coming into play, as well as others. You can also have significant changes of circumstances which will impact on how you're going to try to apply the law. And so it's not to say that knowing the law isn't an essential part of being a lawyer. Obviously it is. It is more appropriate to say that it is not the be-all and end-all of practicing law is the subject matter expertise. That's the base. How we communicate it, how we interpret it, how we ensure that the client understands it is really, from a risk management perspective, the significant piece of the puzzle. So we have other pieces around clerical and delegation areas, depending on the nature of your practice, whether you're working with clerks. Sometimes we do see things go missing. We see forms that weren't properly completed. This can be really significant in areas such as intellectual property law, where a misfiled document could make or break an application. And so at the end of the day, these are areas where you need to manage risk. And here are a few general tips. So first off, doing your homework always is important. To take the time to really know the law of the area you've chosen to practice in and know the facts of each and every case. Take the time with your clients to understand their objectives and to read between the lines to understand whether there might be something unusual going on, or to ask those probing follow-up questions to really understand and to not make assumptions along the way. So you have to be prepared. If you're going to trial, you got to line up all your ducks. But doing the homework, there's just no shortcuts in law. Client management is a significant piece of this, and client management starts from screening your first clients and deciding whether to take them on in the first place, and all the way through to the end of a retainer. It's about managing expectations and continuously managing those expectations throughout. That is requiring constant communication. Basically, just like a board should never be surprised by a staff decision, a client should never be surprised by a lawyer's decision. If you're going to be bill frequently, or if it's at a set quoted fee, you can't change or depart from that unless you've expressly explained why and gotten written confirmation and acceptance of the change in circumstances. People don't like surprises. Your clients don't like surprises. That's where you end up with eroded trust and where you have people getting frustrated with lawyers that can trigger negligence claims. So communicate at all times. Don't tolerate inappropriate behavior though. If you've got a client who's trying to bully you into doing something that is unethical, that you're not comfortable doing, that's when you have to say goodbye. Payments as well. If you've set up your payments and you've had an agreement as to how the work is going to be done, when it's going to be billed, if someone's not agreeing to that or is starting to be derelict on that, if you can't solve it, that might be a red flag, and it's something that you're going to have to communicate with about your client and decide whether it is an appropriate time to end the relationship, having in mind the appointed time of the retainer and whether there's any upcoming ethical obligations, such as a trial. If you're at the eve of trial, you might not be able to get off the record, but barring those sorts of ethical or professional constraints, it may be that non-payment of fees is a reason for you to say goodbye to a client. For everything that you're doing, you want to document it. You want to keep the notes. And that's not just a risk management issue. That's going to make you a better lawyer. It helps you understand where you came from and where you are. If you've got good contemporaneous notes of every client information, every client meeting, if you're able to email them a confirmation of what they have instructed or what you have advised, then you remember what has been done through the life of the file. It's very easy for you to cycle through and see all that has been done on the file to date. You can appreciate the amount of work you've been putting in. If anyone questions the type of work that you've put in, you have it in writing, and you can get the sign-off in writing on your major decisions. Detailed contemporaneous dockets can help for that, but if you're not billing by docketing, if you have some other arrangement, that's okay. You can still keep contemporaneous notes, which will serve the same purpose. In the litigation context, that means using written offers to settle and working them through in writing with your clients. It means that if there's a back and forth in the negotiation, that you're keeping notes of, we started here, they came back here, we came back here, and checking in with your client at all stages before there's a final offer and acceptance. So that means constantly contacting your clients, staying in regular communication with them through reporting letters and others. And if you've done an intake and it's clear there's no relationship, you want to send off the I am not your lawyer letter confirming that you met but that you are not retained, and to seal that off. So we touched on this earlier, but money is a real sticky point. Obviously, you need to manage client expectations throughout. If you're working on an hourly retainer, it's helpful to get a sufficient retainer at the start. If you're fixed fee, you want to make sure everyone's clear as to what is included in that and stay true to budget. You want to bill regularly if you are sending out for your work on an hourly or stage-based basis. You want it to be regular, and you want it to make sure that it's not coming as a surprise to clients. You need to replenish your retainer when it's running out, and stop where permitted if clients are getting into disputes. We recommend not suing for outstanding fees, by the way, because that often leads to a dressed up negligence suit, and then you're really in the thick of it. So knowing the big categories of risk, we can now look at COVID-19 and where we're at. And if we look at those areas again, the top areas of risk around communication, inadequate investigation, time management, and error of law. There are a couple of other areas that at practicePRO we focus on quite a bit, cybersecurity and fraud. So what I'm going to do is just walk through a few of the areas we're seeing in COVID that relate to each. In communication, simply put, the move to video conference meetings is a fundamental change. You are no longer meeting face-to-face with your clients in almost all circumstances. So there's a certain meeting netiquette, if you want to call it that, and adjusting the tone, adjusting to be there for clients in this new environment. Just like you might not be totally comfortable seeing your face all day on Zoom, I can assure you your clients are probably feeling that, especially when they have to get into deeply personal information. If they're updating a will, for example, and are talking about the children, or talking about a family law dispute, talking about how their business is going down the drain and they may need to contemplate personal bankruptcy. These are deeply personal, sensitive discussions. Doing it over Zoom for some people, no problem. I'm used to it, easy peasy. For a lot of people, that's different, and it's going to take some adjusting, and you need to adjust. So that means adjusting timeframes. You may have seen already that for some types of meetings, it's going to take longer over video conference to establish that trusted relationship with your client. And it may be that people get fatigued from doing this by screen as opposed to in person. It's also harder to check for visual cues, and you really need to take the time to ask and probe deeper and really understand the client's circumstance, but it may not be under one meeting. It might take a few meetings. So we've got some resources for that online at practicepro.ca. We've got a Zoom security tips sheet. We've got a checklist for providing legal services online. We also have some other articles around effective video conferencing, and so I encourage you to check those. But once again, just like anywhere else, just because the meetings are virtual doesn't mean you don't want to confirm things in writing, an email back, a written retainer agreement, defining the scope of the service. All of those are must-haves. For time management, we're in a weird place. Some people have noticed working from home that time has ceased to have all meaning. And that's kind of true, but it isn't. For those of you in litigation, the limitation periods have been suspended, but there's some significant carve-outs. Construction law is still moving along. If you practice in construction law, if you have a lien, all of the normal requirements still must be met. You need to file that trial record within 2 years. You need to file that lien within the time periods prescribed by law. If you're not sure about what those time periods are, practicepro.ca has a flow chart to help you with that. Contractual limitation periods don't stop under the emergency orders that were introduced by this government. And so if there is a contract that is governing the dispute, you have to check for the deadlines there. Of course, some limitation periods may be suspended in other jurisdictions, but the order doesn't apply to that. And so depending on which area of law, even if the choice of forum is Ontario, if you're looking at other jurisdictions, you need to be mindful that there may not be a suspension of deadlines. So that's on the procedural court side. On the practice side, there's a significant change in how we are managing our time. It's not 9 to 5, it's not in point ones, it's on what we can get done, when we can get it done in a time that works best for us and our clients. And this isn't working from home. This is working from home during a pandemic. So everyone's schedules are upside down, and we're really just trying to be as collegial as possible and as empathetic as possible and understanding of where our clients are at and where our colleagues are at and where lawyers on other sides of transactions are at, and trying to do the best work we can in very challenging circumstances. productivity is going to be impacted by this. And that's something that as lawyers, if you're running a small firm or if you have carriage of your own files, it's really helpful to think about triaging and looking through your file list, checking for deadlines, checking about your clients' needs, checking in with your clients, but also coming up with, the must do, would like to do soon, can push off type of list if you're finding that you are struggling because there aren't enough hours in the day for you right now. The error of law issue that I mentioned earlier is actually something that is a bit more of a higher risk right now. We see changes virtually daily right now around what types of employment programs are available. This can impact on what type of advice you might be giving employees or employers. We've seen the limitations period frozen. We've seen wills and powers of attorney that can be remotely executed. We've seen changes in real estate law. And so all of us need to constantly monitor for updates. A few good places to check for updates in addition to practicePRO.ca is the Law Society's website that has a COVID-19 page and can help you navigate your FAQs around your ethical obligations and how the Law Society is permitting remote execution and online services. As well, the provincial government has its emergency webpage as well. So when we turn to cyber and fraud, unfortunately, some bad agents are out there looking at this as an opportunity. We've seen some fraudsters try to take advantage of COVID-19. We've seen some people here who have been purporting to be the WHO or who have tried to do spear phishing attempts, taking advantage of the changes in technology and use to try to get people to hand over money in one way or another. So you need to be on alert for cybersecurity and fraud efforts. There's been a lot of talk about Zoom and whether we can use it and whether we can. There's an article that we have on practicePRO.ca that goes through some of the issues. Zoom recently did a security upgrade, and at the moment it's being used by courts, it's being used by CPD providers, it's being used by a lot of different businesses. Some of your clients may choose not to use Zoom, and that is their right. There are other tools available, but by and large, for most types of meetings, at the moment, it seems as though as long as you use the security measures that are available, such as setting meeting passwords and not sharing links, you can safely use Zoom at this time. Continue to monitor, of course, for updates, but at the moment, it looks like we're okay there. Of course, your clients are also vulnerable. Some of your clients are vulnerable to becoming victims of fraud or undue influence. And there's a risk of some people presenting as clients who are really just there to try to take advantage of the fact that you run a client trust account. And so you need to make sure that you're taking the time to understand you need to understand your clients, who they are, check ID, understand why they've come to you now, etc. So let's go to the next slide now. I do see there's a couple of questions. I think one of them I've addressed. In terms of the suspension of limitation periods, I'll deal with some of the minutia after the presentation, but just rest assured I'm hearing your comments. So I've already talked about remote practice security and the resources we have available. And really, that's just one of many steps that we're all taking to work from home. So some of you may have been thrown in there. And so I'd like to spend about 5 to 10 minutes just talking about some of the tools that are out there. Really, at this point, you don't need to re-envision your entire practice and your entire process. There are a lot of different tools available, often not exclusive to lawyers, that can help you become more productive and to keep you in constant contact with your clients. So we have an article as well as a chart of these resources on practicePRO.ca. The bottom line is sometimes lawyers are afraid of using tech, but tech can actually help you manage your risk. There's the 1.0 starting point for small firms and for lawyers. You need your bricks and mortar type of tools, or your 1.0 tech, I should say. You need your computer, you need your your intranet, you need a printer potentially, you need remote access, you need a secure VPN or other remote access network, you need some way of scanning and storing files. You probably are relying on a smartphone, and you need some sort of system. It doesn't have to be an actual physical fax, but you need some sort of system that can replicate the fax system that the courts may require for the time being. At the end of the day, each of these have some risks that need to be managed around physical security and network security, and that means that you need passwords and encryption and antivirus protection, and you need to keep your software updates moving. For Zoom users, that is one of the issues that is important, is that the new upgrades came in about a week and a half ago. If you aren't on their latest version, you may not be benefiting from all of the security, and so make sure you're using up to speed software. You want to do the basics, like locking your phone so you don't end up like Rudy Giuliani, but dialing a reporter and talking about confidential matters. So you want to make sure that you're using, you have remote wipe in case your phone is lost, that you're using the various security tools that are available. For cloud storage, a couple of years ago, there was still a lot of questioning about whether you can store data in the cloud. I think we've gone to whether, and now it's clear that you can. The question is how. And so we want to see lawyers with data that's stored ideally on Canadian servers, that's encrypted, where it's password protected. You don't just click a link on your computer and magically end up in your data field. We'd like to see some password protection when you're there. So now we're seeing a real shift to Tech 2.0, where we've got all sorts of lovely tools that didn't even exist 3-4 years ago. And so here are just a few, and we're going to rapid fire through some of these. But you know, in terms of video conferencing, there's Zoom, there's GoToMeeting, Skype, and Microsoft Teams has Skype embedded in it, but or sorry, a video function embedded in it. There are all sorts of ways to have meetings with clients, meetings with across your team. And it's really exciting to see this has developed. If your client doesn't want to use Zoom, that's fine. There are other options. WebEx is used by a host of larger firms. Not everyone will want to use that or invest in subscription services. Zoom is, as I mentioned, appears to be the good enough at the right price point. So there's a real democratization of technology right now. As I mentioned, we do have video conferencing checklists available already, and articles on this, and some tips for hosting the Zoom meeting. In terms of productivity from home, there's lots of fun stuff, starting with editing. Lots of great tools that are out there. So you've probably already seen a YouTube ad before your video for Grammarly, but there are others. Text Expander is one of these programs where you can put in whole paragraphs, and with the click of a button, it can insert into a standard letter. I use WordRake. WordRake is a lovely tool that embeds right into Microsoft products, and it allows you to cut some of the wordiness in your writing. It's all optional. It runs kind of like track changes, so it doesn't do it without your approval, but it does help you look at your writing from a fresh perspective. And it was designed with lawyers in mind, and a lot of Latin and legalese gets struck along the way. So not 100% accurate in terms of some of the changes it will make. You need to check it carefully, but a lovely tool to try to get your writing down, focused, and clear for your reader. Of course, voice dictation isn't for everyone, but those who use it often swear by it. You can use your phone. There are products right through Google that'll help you voice dictate onto Gmail, for example. Dragon is still an industry leader. Very good use cases available through Dragon for dictation. There's an app for it, and there are others who provide dictation services as well. We've got a bit more detail about that in our online tech tool chart that you can download from practicePRO. Calendaring's come a long way. I mean, I remember when I started as a litigator, having to create these charts myself about who's available, when, for how long, and then it would all fail again, and I'd send out another round of emails. Well, now that's all done, but it's at a click of a button using Doodle. You can use other tools like Calendly that can integrate straight into your website so that people can set up meeting times with you and really streamline and enhance customer service. So you can check out some of these demos online from the providers. I'm one of the people who likes having a big canvas to think through ideas. And if you're like that, or if you just need to keep things organized in a note type fashion, there are lots of tools like Microsoft OneNote or Evernote that can allow you to clip images, download web page data, save your notes, link to resources, and keep all of your materials related to one file or your marketing or your outreach or whatever it is that you're working on right in one spot. So lots of ways to manage data, lots of ways to manage tasks. Another way to do that is with task and project management tools, things like Trello that take the sticky note, first this, then that sort of approach, and lets you build those out in real time on an app that can be shared with your team. So instead of emails clogging up with attachment 1, attachment 2, attachment 3, you can actually be delegating tasks and watching through a console to make sure that these are being met. Lots of lean practice management techniques being developed by lawyers who are working collaboratively with staff through these sorts of tools. Now, there are different ones. There are some that are more visual than others, companies such as Reich, some that provide Gantt charts, but Trello is one of the leaders. And all of that sort of leads us to practice management software. Basically, this can become the operating system of your practice if it is worth your while. Practice management software tends to build in many of the tools we've just described or works with some of those modular pieces. They can work with cloud storage of your documents. They can work with your intake forms and help you with automation. They can help with your billing. They can take bill payments at times depending on your provider, and they can have calendaring and task management. These can be very helpful products for you. Some of them also have add-ons for customer relationship management that can help you manage to determine your impact with the number of touch points with clients, the value of each client, how you might and use those data points to decide how you'd like to grow your business. Some of them have built-in trust accounting for Ontario standards. Some do not. There are a whole bunch out there, and they are they're really range in what they offer. Groups like Matter 365, for example, builds straight off of Microsoft Office and the Microsoft suite. Clio and Clio Grow, obviously Canadian companies. Clio Grow is more of the CRM. Clio Manage is more of your general practice management software. Cosmolex is an American-based company by Tabs 3, but they're now in Canada as well. So lots of different providers in the Canadian space. LawPro doesn't endorse any particular one, but it is helpful for you to get a sense of the types of things that are out there. And what's nice about all of these tech products really that we've been showing off today and featuring is that they typically either are no to low cost when it comes to the calendaring type apps and the Trello type apps or those sorts of things. And when it comes to case management or matter management software, some are being given away at the moment on trial. Others are at a certain amount, but you can call them, and many of them will sign you up. But you can try it out for a month and decide whether it works for you. So lots of ways to explore with tech in this day and age. And that brings us to research, because we're all sort of stuck at home. There are lots of wonderful online legal research tools. The Great Library has expanded some of its offerings. TLA Library is wonderful and has great online resources as well. And for the great reopening, when we get there, it's a lovely place to spend some time. But in the meantime, Canly is a great resource, and it's been expanding lately. There are lots of new features. If you have the time, go play with them a bit. They've got new secondary sources. They've got new note up features. They've got a lot of case commentary provided by lawyers, and it's really come to a next level. And remember that online isn't always enough. In this day and age, it's going to have to do, because we can't get to the Great Library, and I just love this picture of it here. but do know that, the Great Library does have a research information network, and the local libraries as well. You can call them up and say, hey, I'm looking for a particular case that I can't find online, but I see a site to. Any way you can help me. So that's for down the road for when staff is in place, but it's important to remember your law libraries are there, including TLA. Another great research option, online legal research. Canada's got a robust law blog culture. You can go to lawblogs.ca to see all the different areas. Some are around practice management, like ours at LawPro. We've got practicepro.ca and avoidaclaim.com. But you'll see that there are a lot by area of law as well. So if you're in employment law and trying to keep track of all the updates, subscribing to some blogs doesn't hurt. So let me spend a few minutes in wrap up talking about where we're at now and some tips for the long run. I think it's really important that we remember that, the career path is a long one. It doesn't matter if you were trained, if you went and you completed your law school in England and Wales, or in Australia, or in Toronto, or in BC, or anywhere else for that matter. If you've been called to the bar in Ontario, welcome. These are tough times, but it's also a long run. The career path is long. And so both for COVID and for the career path, it's important to remember this is not a sprint. We may have thought initially that COVID would only be a short period. It's clearly been a bit longer. It's important to put that perspective in mind and remember to take our breaks. So first off, just my note is I think it's important that we're all mindful of the circumstances we've been working under and be proud of the accomplishments we've had. The ability to pick up the phone and reach out to clients to see what they need, the ability to check in on one another, the ability to provide mentoring or support to each other during these times, I think are all wonderful hallmarks of our profession that I've seen in droves through this difficult time. So I think we can all pat ourselves on the back a little bit. And I think now more than ever, it's really important to stay connected with peers, and groups like the NCA Network and TLA are fantastic areas where you can meet like-minded lawyers and have support systems in place where you can learn from one another, where you can reach out, network, meet other colleagues so you don't feel isolated, both socially but professionally as well. So that if you're in a small practice and you've got an ethical issue, or you're not sure how to set something up, or you're curious about business planning or about how to run a particular marketing campaign, you can pick up the phone or send out an email or do a Zoom coffee and chat with some peers, because we've all probably seen it. It's important to take our breaks and take our breathing now more than ever. There are all sorts of lovely apps to help. The Calm app is a relatively low-cost app that you can use to schedule in some time, but there's lots here that is stressful and where we don't quite know what the end date's going to be like. And so we can't just be burning the wick at both ends right now. We really need to pause and take our breaks. So let's just move forward a little bit. So I discussed this a bit already about taking our breaks, and one area is family and friends. Find your comfort spot. There have been a lot of discussions about how even in the time of social separation, people are finding that they are having more meaningful conversations with peers in the time that they do connect, or that they are reaching out to old friends and family and finding their communities. And so I'd encourage you to find the areas that give you comfort and give you joy, and reach out, and not just now, but just through the, during the reopening and onward. These were pieces of advice that we were sharing even before our shutdown. And of course, there's been lots in the news about mental health and assistance given COVID, but lawyers have disproportionately been susceptible to mental health issues. And it's not clear whether that's people. What the chicken egg question is, are these people who are predisposed, who are applying to law school and becoming lawyers, or is it people who are working as lawyers who have taken on the burdens of others and the practice pressures, and it is difficult? Might be a bit of each. I don't really know. The point, though, is that we do know that lawyers are taken care of a lot, are part of the backbone of our rule of law, do embrace a lot of disputes, a lot of their clients' pressures, absorb a lot, and it can be very difficult. If you're finding you're struggling, we have free and confidential services available. LawPro is a co-funder of the Member Assistance Program. It is operated independently by Homewood Health. We believe that it's important that lawyers are healthy and that assistance is available so that healthy lawyers can have healthy practices. Key points here, it's not just available to you, it's available to students, and it's also available to your family members. So anyone who might need to reach out, we're there for you. There are all sorts of resources. There are, if you register in, there are all sorts of resources, articles, and courses. There's also short and longer term counseling and some lifestyle coaching as well around a whole host of issues that people in the sandwich generation are facing and people with young kids are facing, as well as around nutrition and smoking cessation. So lots of really practical, helpful resources available. So for looking for more, I'd encourage you to come to practicePRO.ca. If you see that hot topics button, if you click on it, you get to our COVID-19 resources. We also have our managing series, and there are lots there that are helpful right now if you're trying to step back and reflect on how you want to do things differently in the future. We've got a managing series around with resources around how to manage a better professional services firm, and as well as our disaster planning guide. They're slightly dated, but the nuts and bolts are effectively still useful today. So I'd encourage you to have a look at them. For cyber insurance, given that we have moved more to remote, we do have a limited cyber crime coverage up to $250,000. If you're not sure whether that's enough for you, feel free to check our articles on cybercrime and cyber insurance, or call our customer service line if you're curious about what's available. You might want to consider additional coverage. We also have all sorts of resources through our COVID-19 page to help you manage with some of the changes in practice standards. We've seen changes in how wills are done, for example, and we've got articles about that. And with the increases in cyber COVID-related matters, our Avoid a Claim blog, where you can subscribe, will give you updates, not just on fraudsters that we're seeing, but on some of the other resources as we're pushing it out. So these are the key websites, avoidaclaim.com and practicepro.ca. Again, if you have an issue that's making you concerned, you can always call LawPro. You can call us and say, I'm worried that somebody might be actually trying to use me and dupe me. I don't want to be a bad actor, and we can help walk through that. So feel free to pick up the phone. You can also call a colleague if you're ever unsure. And for some deeper reading, and our most recent magazine is actually timely, it was about mental health, you can check our LawPro magazines. They're all available on practicepro.ca. So I'm going to wrap up here, and then we can take a few questions, but here are the key lessons. It's important to reflect on where the risk points are in your practice. Claims are real and they're preventable, but by understanding the risks, you can do lots to be proactive and to reduce your risk, and that will reduce the risk of either a claim in the first place or there being a claim that has merit. With the work from home shift and the shift to what I assume will be a more connected form and more tech-reliant form of delivery of legal services, tech can help. And the question isn't whether, but how, and how to do so safely. So you should be actively managing your practice and yourself. Watch out for fraud. Don't be afraid to pick up the phone and ask for help if you're not sure about something. And remember, be it for fraud or for wellness and mental health, or for how to get from A to B in your practice, there are supports and there's a community of individuals, associations, and groups like LawPro that are there to try to help. Thank you all for coming. It's really lovely to see so many people out in one go. This is eligible for risk management credit. LawPro has this credit available for lawyers who take CPD that relates to risk. And so for next year's premium, you can select that you attended today's webinar, and a $50 premium discount will be applied to your premium for next year. So please stay in touch. Thank you so much for having me. And I'm going to stop there, check the question bar, and perhaps we can open it up for the next few minutes. So let me start. So there's been some questions about content and whether the presentation is going to be made available. And I mentioned that we're going to look into that. In terms of best practices for information and document security when working from home, we've addressed some of that. But by all means, feel free to be in touch with me directly if you have specific questions. I'm happy to chat further. In terms of the interplay between contractual periods and other limitation periods, the point generally is that if there's a contract that has a deadline in it, that contractual deadline will not be impacted by the emergency order. So sorry if that wasn't clear earlier. But I think those seem to be the only questions at the moment. But let me just see again on the chat line if there's anything that came in through there instead of the Q&A. Okay, we've got a follow-up question about security, and it's a really helpful one about what to do with physical documents when you're working at home in a makeshift office. We're all doing our best here. I would say that at the moment, it is possible to order from Staples or to order from other online providers. You can buy shelving units that do have a lock and key. If you can do that, that's wonderful. If not, and I understand not everyone has the space for complete new systems here, some sort of filing system so that if you're living alone, less worried about it. If you live with another lawyer, hopefully you're not on opposing sides of the same issue. But point being is if you're living with other people, as long as you've got a secure area where you can keep your documents separate, where you can try to make sure that no one will access them, that's the best we could hope for right now. Try to keep them under lock and key if you can, but if that's not feasible, right now we're in the good enough. And we're all just trying to do the best we can to practice safely. So there's been a question about if you are a US trained lawyer providing American advice, how you can obtain insurance. And the answer is you're going to have to go and seek that elsewhere. There are American-based insurers that provide legal advice. You could check your bar association for the jurisdiction you're called in, and they will likely be able to point you in the right direction. If you're in Oregon, then it's a mandatory program, but in the other places, they're either preferred or open market insurance products available. And, finally, there has been a question that I'm seeing come in about how to manage risk given the economic downturn. And really, it's back to first principles around managing your client's expectations. If the court is closed and that's pushing off litigation, you need to advise your clients. That's where it's at. If there are difficulties with the other side refusing to respond to matters right now because courts are closed, you need to simply advise your client of where things are at and the limited tools that are available. It's important to continue to communicate with your clients, communicate about changing situations. For sure, in economic downturns, there's always a risk that people will be disgruntled. People may turn against their own lawyers. As long as you are candid, transparent with them, providing the best service you can, you're doing what you can, and we will cover you, assuming that, that you're doing what needs to be done along the way. So I think that's all we have time for today. I think I've covered all the questions. If I missed something, please feel free to email me separately offline and we can chat further. But I really want to thank everyone for coming today. Thanks to the NCA Network and the TLA. It's been a real pleasure.